live now? Sure.
This number one, number one. Give me pata. Give me pata.
Of the order marks, page number 3, second line marks, the court designation has been checked. Senior civil judge and JMFT Raibal instead of principal family court at Koppal.
No, in the operative portion.
Yes, that is
Pending on the file of the principal judge family court at Koppal. It is
Koppal, it is senior civil judge and JMFT Raibal.
senior.
Civil judge and JMFT Raibal.
In the order, instead of mentioning senior civil judge,
And JMFT Raibal.
JMFC Raipal, it is mentioned as principal judge family court at Koppal.
No.
Koppal. And the principal judge family court Gadak is correct.
It is correct.
Accordingly, the registry shall upload the corrected copy.
Yes.
Next.
Enforcement still number two.
Please, ma'am.
Yes, and
I paid the PF.
You paid?
Yes, ma'am.
It is submitted at the needful is done. Just after service of notice. Yes.
still number three.
Zero.
Three.
Please, transfer petition filed before the principal district and sessions of dismissal. Against it, no appeal lies. So, under section 115 Act for division, the office has raised objection about maintenance.
Where is that? No, I guess this order, CRP only filed.
Please, similar matter also recently disposed of CRP number 100107.
Yes, against the dismissal, CRP only lies. What else should be? Because they have no other remedy. Then what is this objection? Call them. Yes, next.
Still number four. Sadiq Still number four.
Move a memo and not represent the matter. In spite of moving a memo and the matter is listed, no representation. This is matter after vacation on February 3rd. Yes.
Still number five. DSLP.
May kindly put on 18th, my lord. The same statement is not filed. The office
Why the memo is moved for this?
Memo, because I am under the impression that everything is complied, my lord. But
Office objection shall be complied. List this matter. When you will comply? One, list this matter immediately after the office objections are complied.
yes.
Yes.
Still number six. Then now.
No representation. List this matter on February 4th. Yes.
For dismissal matter, still number seven. This is Jnanaya Swami. This is Jnanaya Swami, still number seven.
The petition RPFC of 2022. The petitioner has not even paid the process and certain office objections are not complied with. On 23 and 2024, a week's time is granted to do the needful. By the time the needful is not done, direct the matter to be listed at the caption for dismissal. Today the matter is listed in the caption for dismissal, and today also there is no representation. Dismiss for non-prosecution.
Needful has been done.
Done. Land council submits that the needful is done. Delete from the caption for dismissal. List after service of notice. Yes.
Seal number 8. Hammatandi Soka. Suraj Balloli.
Yes.
Respondent not is the father. Petitioner, respondent is the father. He has filed a 125 petition against the son. The earlier what has happened?
How much is granted now?
5,000 is granted. In fact, there is already a partition. In the partition, he has got two items of property. That is exhibit R1 and R2 produced. Survey number 131.
What are those exhibit R1 and R2?
They are the record of rights.
Oh, that's true. It
Yes.
must be an agricultural land.
Yes, agriculture.
No, just because he has got something and in spite of that, he is not in a position to maintain himself. What is it? Is it not why you fight for 5,000 the children or for the court?
Not his children.
Uh.
Here, I am ready to pay whatever the amount he is required, really required. He is not come and stay with us. What is happened? There was a dispute between the father and the mother. She filed a maintenance petition. Thereafter, divorce petition. Thereafter, mother has filed a suit for partition when I was a minor. And partition was taken place. After the partition, he has not given share. Thereafter, I approached the Spousal court. In spite of the decree, he did not get the. He has objected for my name to be entered in the revenue record. Thereafter, I filed a petition before the Spousal court. The Spousal court directed the authority to enter the name. This is how there is a.
Correct, but let the son be magnanimous, father is not.
I believe being the son is a bounded duty.
But up to the amount that is granted is not something very huge.
No, 5,000 is not the criteria. The criteria is my entire ground of the objection before the trial court is he is not come and staying with us. We will take entire care. And he is with the other.
No, it's the same way, like how the husband says that I want to take care, but the wife is not coming and
Husband and
staying.
wife is a little bit different because they are
No,
going
he
to
may be having issues with the daughter-in-law.
But thing is, daughter-in-law is taking care, but he is adamant nature. We are.
That's why let him live his life, give him that 5,000 and keep quiet.
The thing is, already he has got the lands and he is able to.
What is his age?
At the time of filing, it was 61 years. It was 61 years.
62 years, that I have stated in my first title before this Spousal court. And it is only because of the dispute between the parties with regard to the civil litigations that I have filed suit for partition. This is how vengeance he has filed his murder.
That's true. That's something which cannot be taken judicial note of.
But the thing is, if he has no source of income or he has no property at all, he has got the property partition. That with great difficulty, we are taken the possession. And because of that reason only, he has filed the maintenance. He is not at all required any, and he has sold some property. He has got the lakhs to
Let's give that benefit of doubt.
Please.
Let's give the benefit of doubt. Please come. The agreed with orders passed and criminal miscellaneous number 52 of 2023, dated 3rd January 2024. The son is before this court. The father has filed the criminal miscellaneous seeking under section 125 CRPC, seeking maintenance of an amount of 20,000. It is the case of the father that there are disputes between the father and the mother. And the mother had instituted voice number 93 of 1998 for partition before the civil judge in JMFC Haveli, which was decreed, whereby half share was allotted to the son. As for the said partition, 23 guntas, 12 annas out of the extent of 5 acres, 10 guntas, in RS number 73 of 1A, and 10 guntas, 14 annas out of 2 acres, 14 guntas, in RS number 135 of 5B, has been allotted to the share of the father. Who is the petitioner?
Son.
Before this on the court, or before?
No, no, no. Before the court refers to
Father. Father has filed the maintenance.
the husband, the father. No, here's some confusion with the frame of the sentence.
Yes.
The son who has to pay maintenance to the mother has sold, and also for the heart operation has sold the property allotted to his share, and is not having any source of income to maintain himself. Hence, he sought for maintenance of an amount of rupees 20,000. The same was resisted by the son. The court had granted maintenance of an amount of rupees 5,000. While passing the order, the court has observed that the father requires basic necessities like food, clothing, shelter, and medicine, and an amount of rupees 5,000 per month would be a fair and reasonable one, reasonable maintenance. The court observes that the father is entitled to lead a life with the standard of life available to the son, besides inclusive of basic necessities agreed thereby the son is before this court. Learned counsel for the appearing for the son submits that the son is ready to take care of the father, and the father is reluctant to join the son. It is submitted that in view of the civil disputes and the restitution of the partition suit, the present proceedings are initiated seeking maintenance. It is submitted that he is in the partition, certain properties fell to his share, and he is in a position to maintain himself. In spite of that, the present petition is filed, and the court, without considering all these aspects, has granted maintenance to the father, which he is not entitled to. Next part. Learned counsel appearing for the respondent submits that he is suffering with several ailments, and in fact the property also he has sold. And when he is not a position to maintain himself, he has come up with the petition seeking maintenance. Court has considered, and in fact, when the father has sought for 20,000, court has granted only 5,000, which is a meager amount. Even that is also questioned by the son. He submits that the son has a responsibility to maintain the father, who is not in a position to maintain himself. Next paragraph. Having heard the counsels on either side, there is some material on record. It is a case of the father that is not able to sustain himself, as property which fell to his share is already sold for providing maintenance and for the medical needs. It is not a case of the son that he is not in a position to maintain the father. Only contention is that the father is not joining the son, and they are ready to take care. For the father not to join the son, there could be various reasons, and considering the fact that father has no means to maintain himself, and the son is capable of maintaining the father, the considered opinion of this court, the trial court had rightly granted an amount of rupees 5,000, and this court finds no reason to interfere. Accordingly, dismissed.
Great. The present petitioner in custody, my lords, if I take the exception.
After vacation,
Please.
delete from the passage for dismissal. This matter, 23rd. Yes.
Admission matters.
Kindly pass over.
No
For
password.
respond to this. Kindly pass over.
Which matter?
Serial number 10.
Serial number 10 will.
You represent whom?
I'm representing responsible.
Counsel is here.
Yes, sir. For this question.
No password. Any objection to this matter?
Yes, sir. So in the court instance, there is one more factor.
Move this matter after vacation. Your principal separately. Not better separately. January.
Silmalaman,
The request of non-counsel petitioner. Yes. Proceedings. Take that. So nothing has started. Use the mic.
Bulk petition seeking transfer from the Belgaum
The present petition is filed. Seeking transfer of MC number 331 of 2022 pending on the file of the Family Court Belgaum to the Principal Civil Judge Belongal. The facts of the case are the marriage are taking place on 9/5/2021 at NK Hubli Village, Toor, Belgavi district. In view of the differences between the parties, the husband had filed a MC number 331 of 2022 before the Family Court Belgavi seeking divorce. Then the wife on 11/12/2022 had filed criminal miscellaneous number 649 of 2022 seeking maintenance on the file of the Principal Civil Judge and JMFC by Hongal, and the same is pending consideration. It is submitted that what is the distance?
more than 25 kilometers. More than 25 kilometers.
It is submitted that any issues in the word doc submitted that the distance between the places is 45 kilometers and it's difficult for the wife to travel on every date of hearing. As such, the sought for the transfer. Next paragraph. Though notice is served, there is no wakalat is filed on behalf of the respondents. Next paragraph. Having heard the accounts for the petitioner, peruse the material on record, concerning the fact that the wife, already the criminal miscellaneous is instituted on the file of Principal Civil Judge and JMFC by Longal, and further considering the distance between the places is more than 45 kilometers. This court is passing the following order. So and so pending on the file of so and so is withdrawn and transferred to so and so accordingly allowed. Yes, next.
Silmalaman, Sharp Bhattati,
Plus 12,500 is my salary. 12,500 is my salary. And my trial court awarded 16,000.
As maintenance.
Please. And last year, the pleading lordship directed me to produce statement of audit.
Assets are liable.
Please, I have to be with the
Because when we look at this accounts matters, there are some perks which regularly this petitioner is receiving. So far as that, there is no explanation as to what those perks are. Every month there are series of
But still, even considering those perks, when somebody's salary is 12,500, how can they do
also
I know
he owns 2 house matters. He has given it for rent. They are not disclosed anything regarding the same matters.
No, either he has,
Regarding
no.
salary, it is,
If he is not disclosing, you should disclose. You should replace before the court. So on assumptions, there can't be any maintenance. So when his salary is 16,000,
and my wife's salary is 73,000. She is the FDA, what's the
then why are you, how are you
FDA
entitled for any
rate?
maintenance? When your husband's salary is, when your husband's salary is less than what you are having, you have any issues?
Three children are there. With regard to them only we are paying.
Not to you.
Not to us.
So even then, no, it has to be proportionate to his salary.
Please, madam.
12,500 is your salary.
Bring salary certificate and statement numbers from the date of petition was filed to the hand, all the statement.
We are actually ready to join the company of the husband, but she is not ready to take.
Unless I filed a divorce petition, it was contested. The same was pending before the honorable court.
Now what are you, then what
There is no
about,
reasonable ground as to why.
who will take care of the children?
Yes, I am not saying that I am not.
No, you are, you are saying it by filing this petition. That amount is granted to the children. You have a responsibility to take care of them.
Reasonable amount. My lord.
What is a reasonable amount according to you?
7,500 is now from the date of this order. I am paying, my lord.
For three
My
children.
salary is 12,500, and once I produce the photocopies of my parents, my father is a paralyzed person, my lord, and my mother is a nurse.
Will confirm the interim order, 7,500.
Please, my lord.
This is the matter you were insisting yesterday.
No, that was another one, that was on Monday, my lord.
The present petition is filed, agreed with the orders passed in criminal miscellaneous number 59 of 2022, dated 15th June 2023. The petitioner before this court is a father. The wife, is the husband, the wife, had filed the petition representing the three children, seeking maintenance of an amount of rupees 15,000 to each of the children. It is her case that the husband is doing business in manufacturing of electric switchboards and also serving as manager at MSIL Dharwad. The children are studying at Rajeshwari Vidya School, the first petitioner, and the second and the first child is studying in Vidya School, and the second and third are studying at Chikati School of Gadag, and she's working as FTA in Gadag district. And she requires
Gadag district court, in the very same court,
she requires minimum 15,000 per month for her to take care of the children. Her salary is 30,000. It is a case that the husband is getting monthly salary of rupees 30,000 and also owns 3 houses at JB Nagar, Dharwad, and is getting a monthly rental of rupees 40,000 from the said houses. It is a case that though the father is having sufficient means, he has neglected to take care of the children. The husband has filed his objections, stating that he is receiving monthly salary of 11,049, and except the salary, he has no other source of income. In fact, the wife had deserted him. As such, he has filed a petition seeking divorce. His father is aged 44 years and the mother is 73 years. Father is suffering from paralysis and is bedridden, and he cannot move without the assistance of respondent. The mother is also suffering from arthritis, and they are all unable to do any work. According to him, the wife is working in a judicial department and is receiving monthly salary of 50,000 to rupees 60,000. The family court, by order in June, had granted maintenance of an amount of rupees
16,000, 6,000 each.
6,000 each, 18,000.
had granted monthly maintenance of rupees 6,000 to each of the petitioner, that is 18,000, till they attain the majority, and till the first petitioner attains, the son attains majority, and till the daughters, till their marriage, and also granted the litigation expenses at 10,000. The court has observed that considering the present cost of living index, social and financial status of the parties, court is inclined to grant 6,000 each. The court had relied on several judgments and about the obligation of the father. And the court had discussed about the amounts that are being spent by the mother for the children. And accordingly granted the maintenance. Learned counsel for the petitioner, husband submits that the salary of the husband is 12,500 and the court grants maintenance of 18,000. Court grants maintenance of an amount of rupees 18,000. He submits that the court, without any evidence, without any material, and without considering the financial capacity of the husband, had granted the maintenance. It is as per he submits that, as per the order passed by this court, he has filed his statement of assets and liabilities, and also he has stated that the health condition, he has to take care of the father and mother who are aged persons and suffering with several ailments. Next one, the counsel appearing for the respondent submits that though as per the salary, as per the slip, he is earning an amount of rupees 12,500. Every month he is receiving several perks. Those there is no explanation coming up in the statement. It is submitted that he is having houses and in Dharwad and he is deriving rent from the same. All those aspects were suppressed by him before the trial court as well as this court. He submits that the court rightly considered all these aspects and rightly granted maintenance considering the requirement of the children and the obligation of the father to maintain the children. Next part. Having heard the learned counsels on either side, produce a mention on the law. This court, by way of an interim order, had directed the father to pay an amount of 7,500 per month and arrears.
I had paid money from the date.
Arrears are also clear at 7,500. 7,500 from the date of petition. I had directed him to continue to pay 7,500 and also arrears at 7,500. It is submitted by both the counsel. It is submitted by the petitioner that there are no arrears at 7,500. Even as per the counsel of the respondent at 7,500, the amounts are being paid by the father, by the husband. There is no dispute about the fact that the father has a responsibility to take care of the children. While granting maintenance, courts also have to look at the financial capacity of the husband and whether the amount that is claimed by the wife is the husband is in a position to pay the same. In this case, the salary is 12,500. In that case, granting 18,000 maintenance, though the children might be having the necessities, is a very unreasonable amount. And the said the finding is without appreciating the case of the husband. In the considered opinion of the court, when the husband is when the salary is 12,500, and as per the order passed by this court, husband is able to pay the amount 7,500 comfortably. The court is of the view that the amount that is granted by the family court needs to be modified. In that view of the matter, this court is passing the following order. The appeal is partly allowed by, uh, by reducing the amount of maintenance from 18,000 to 7,500 to the, the respondent 1 to 3. As far as the education, the legal expenses are concerned, this court is not interfering, and the order of the court is upheld accordingly. Appeal, the petition is partly allowed.
Lord, connected notes we have filed enhancement because connected notes often.
Next, RPFC number 100209 of 2023 is filed. The same order dated.
The 7,500 from the date of petition.
Malona.
7,500 from the date of petition.
That could be, why not?
No, I paid.
He has paid, he already has paid. That's what I recorded that, he has already paid. The developing RPFC 100209 of 2023 is filed by the wife seeking enhancement of the maintenance. In view of the above discussion, in the petition filed by the husband, this petition is liable to be dismissed, accordingly dismissed. Yes.
I had paid 7,500 monthly before this under report. That will be my withdrawal.
All the amounts that are already paid by the, already deposited by the petitioner before this court, the respondent wife is at liberty to withdraw.
Much more.
Branch officer, I
Uh-huh. No, civil petition it is directly. CRP only against that. By which rule says that it should be CP? No, general, because general transfer petitions are CP, that's why you have done. The office objections are overruled. This is matter for execution on Monday. If other objections are is complied with.
Number 30, petition proceeding.
What is this for permission to IA? What is this IA?
41 to 27.
Oh.
There existed before the trial court at the time of returns of the petitioner. There is a plaintiff in notice number 141 of 2017. This is filed for the partition to separate solution. And after the evidence, the defendant number 1 with the contending party has filed the written statement and also counterclaim. The claimant will share the suit property, including all other property, which he claims as the ancestral properties of deceased derived and Mubah, as which is granted by the government. And afterwards, after the last examination of the plaintiff petition, the defendant number 1 has filed application on Rod 711B, that is 151 CPC, requesting to reject the plaint of the present petition plaintiff.
No, you are the original defendant who has filed the counterclaim. Original plaintiff.
Original.
He has filed the counterclaim.
Yes, lost.
Now, after filing the counterclaim, rejection of Order 7 Rule 11 is filed
Fine.
by him. On what ground?
On the ground that under section 80 of the Public Trust Act, the suit property is purely the public trust property, and therefore the jurisdiction is barred to the civil court, the learned civil court. Whereas the petitioner.
Then how is his counterclaim maintainable when your suit is not maintained?
Both are dismissed also. But my contention is that the very contention taken in 7 Rule 11 is that the public is denied by the plaintiff in the awareness of the plaint, which is not properly considered by the learned trial court, and no proper inquiry has been made by the trial court.
No.
To find out the cause of action.
No. According to him, it's a public trust and the properties are the public trust properties, so a suit is not maintainable.
Yeah.
Now, can't you make it out from the reading of the plaint?
That's what the plaint discloses very much clearly that there is a cause of action and that the suit for the relief of partition and separate filed by petitioner.
No, but the property is a joint family property.
Joint family.
Public trust property.
It is a joint family property as per the contentions made in the awareness from para number 1 to.
Let's see the plaint.
Yeah.
Is the plaint at page number 57, 51? Page number 6 of the plaint. The said CTS properties are all registered as a public trust properties under the Public Trust Act, and the certificate of the management of said trust properties is issued in the name of Hassan Saab Mullah, who is the respondent in the RTC appeal number 437. So you also accept that it is the properties of the public trust property.
No, not. Subsequently, para number,
No, this one sentence is enough. You are accepting that these are the properties of a public trust.
But as per the Order 7 rule, the entire amendments of the plaint has to be considered by the trial court to see whether that there is a cause of action. And
No, once having accepted that it is a public trust according to your own amendments, after that whatever amendments you make, this will not go.
But
Property remains to be a public trust property.
no, because as per the document produced by me in 41 to 27, which is exhibited in the order dated 21/6/2016, passed by
No,
the ALR,
now I have seen
it
this.
clearly had that the fraudulent entries are made by the defendant number 1, and prior to him, his father has indicated the entries in his name by fraud. That is held by. And on the basis of that father, we have
What is the statement? Please read it again, the one which I am reading at page number 6. Please read that. From there we will see what is that.
CTS property from CTS number 2214 to 2247 are all ancestral properties of deceased Hidayat Ali Mola bearing his name in CTS records, and the concerned revenue records of these two properties till that is death on 5/4/1957.
No, you say that by fraud, change the said trust properties. You are still saying that it is a trust property. Defendant has fraudulently changed. So whatever it is, your own admission that it is a public trust property. Court had rightly held that the suit is not maintainable.
Further, subsequently in para number for Lordship, I will
Let's
pass
read
on.
it.
The plaintiff submits that from year 1954 till today,
Where are you reading?
the para number 5 also.
In this page number 6?
Page number, that is page number 8.
Page number 8. Submits that.
The plaintiff submits that from year 1954 till today, till the order of the ADL of 23/6/2016 in RTS 29/1/2016, the names of defendant number 1 and his father continually legally were found without any knowledge of the plaintiff and his family, and to the children and descendants of Hidayat Ali and 4 daughters. But in the said RTS appeal 29/15/16, the IDLR has decided that the defendant has made the fraudulent entries in the CTS record, and prior to that, the father of the defendant number 1 has changed the CTS records of the property to his name without any basis, without any procedure of law under Karnataka land law. They do not give any right and interest to the defendant and his father. The IDLR in the said order has said that defendant number 1 is committed a fraud by clearly holding that defendant number 1 has committed fraud by changing the entries.
So, Mr. Counsel,
CTS
I understood that right till the end. According to you, you accept that the properties are the public trust properties, but the defendant has mutated his name in the records. And your cause of action is also basing on the said mutation when the defendant had started doing something, the cause of action arose to you. But the fact remains is that that is a public trust property, and defendant has fraudulently had mutated the name. Once it's a public trust property, the suit is not maintainable for any other cause.
My submission is also before this honorable court is that from the averments of entire averments has to be considered. First of all, Order 7 Rule 11 contempt of that entire averments. And in the light of entire averments, the honorable court can definitely help.
I have read the entire thing.
Trust property. Because
Who said so? You're only saying, court is not saying that it is a public trust property. You say that it is a public trust property. Defendant has illegally mutated his name.
But further in para number 5, we have contended that defendant number 1 is the father. Because the contention of the other side is that the 1991, the trust has been formed and there is some registration. And that registration certificate is also not
Tell this court one sentence. Where did you say that it is not a public trust property? You already said in one para, it's a public trust property. Thereupon only you are harping upon the fact that the defendant has made the illegal, his name is illegally mutated. And the character and your assertion with regard to the public trust, nowhere you have changed it. It remains to be your stand.
No, sir, my stand in my submission before this honorable court is that as per para of entire awareness, we are contended that the defendant number 1 has changed by fraud, and before that, the father of the defendant number 1 has also changed by fraud only. It means that for registering the trust also,
Where did you say that? Where did you say that? That one sentence you show to the court.
Therefore, plaintiff submits that defendant number 1 and his father have never had got and acquired ownership rights over the property or other ancestral property, and all the entities were bogus and as such they real.
That is with regard to the mutation of their name, not about being a public trust property.
I contend specifically that there is no ownership right. When there is no ownership rights, definitely the provisions of Bombay Public Trust Act do not come into picture also. My submission is that for provisions of Bombay Public Trust Act come into picture only if the defendant number 1 satisfy that the food property is a public property, public trust property.
Your own
definition of the public trust.
Your own definition, your own admission. Nobody else has to say, because what defendant says doesn't matter. In the petition under Order 7 to 11, what you are saying in the plaint does matter.
My submission, Lordship, is Order 7 to 11 contemplates that the plaint has to be rejected. The motive behind the motive of the legislators in enacting the provisions of Order 7 to 11 is that the unnecessary litigation shall be stopped, and the unnecessary litigation, the rights arising out of the rights that may be arising after judgment by unnecessary and the suit may not maintainable should be avoided. But here in this case, as per Order 7 to 11 only, clause B, which contemplates that the defendant or the party is seeking to reject the plaint has to show the total exclusion from the jurisdiction of the civil court. Then only Order 7 to 11, it means that 7 to 11 contemplates that the defendant number 1 has to satisfy that the suit property is a trust property and Section 80 is very much applicable.
Order 7 to 11, he doesn't have to, sir. Court will not look at his arguments. There is nothing like proving it. Court has to look at your plaint evidence which supports his case. Court is looking at it. It is your case that it's a public trust. And you are questioning, you are saying that defendant has played fraud by mutating his name. You don't even say the so-called or the fraudulent, nothing. Please come to the impugn order. Where is the order?
What is the page number?
Page number?
9. Page number 9. Internal page number 9. 100.
Para number 14, please read. Please come. Yes. Agreed with orders passed in I number 8, invoice number 141 of 2017, dated 29 September 2023. The plaintiff is before this court. No, when the plaintiff is rejected, how can there be a revision? It has to be a first appeal.
For rejection of the claim, 7 rule 11, upper remedy in next petition was revision.
No revision. If your application under order 7 rule 11 is rejected, then you will file a revision. If it is allowed, it has to be a proper appeal, regular or first appeal.
Please.
What is to be done now?
Liberty of the plaintiff.
What liberty? No.
File the appeal.
After these many.
Because there are documents.
How is it entertained? The agreed by the order passed by the court whereby the plaintiff is rejected. The plaintiff is before this court. The office also not questioned on the maintainability. The against an order whereby the plaintiff is rejected, the agreed party has to file a regular appeal, but they cannot file a revision. This revision is pending before this court right from 2023. Then concept of the petition of plaintiff submits that the liberty may be given to file the appropriate appeal, to avail the appropriate remedy. Accordingly, this revision is dismissed as non-maintainable. The appellant, the petition is at liberty to avail the remedy subject to the law of limitations and other aspects. Yes. Yes.
Number 40.
Waiting for the response. Yesterday, after taking time, I have intimated you. But before this,
How can you take time and inform?
my lords, on the last occasion, after reading.
Not last occasion. Now please look.
One second, why you are interpreting?
And I don't like this advocates exchanging arguments like this, particularly in my court. You want to say anything, so you got this to the court. And on the last occasion also I've seen both of you are indulging in the same thing.
No, my lords, on the last occasion.
No, please understand. And specifically before this court, before mentioning the counsel shall inform the other side counsel, otherwise mentioning will not be entertained. You should mention to him and tell the court.
He is coming from some other village. At that time, he was not present in the association. I told my colleague to took time. Then later I informed.
And we are again going to the same point. If you cannot, please understand, Mr. Counsel, if you cannot inform, if you are not in a position to inform him, you should wait till the matter is reached.
Please. Unnecessary is.
No, for you it may be unnecessary. For him it is necessary.
No,
so you cannot say that it is necessary.
I have argued for your worship.
It is not about. It is not about what you have argued and what you have done. It is about the rule that you should inform the counsel and make a mention. Somebody might be, they may have their own necessity or the urgency. Court will appreciate
please,
that.
Please, I don't. On the last occasion, my lords, after hearing sometimes have posted the matter day after tomorrow. At each instance, after 15 days, this matter was posted.
It is now the fact remains you have not informed him before doing it.
No, it is his submission on that day before the trial court that he had argument before Martial court. It is his submission. On the last occasion.
We are not going into all that. We are only on the point whether yesterday, before seeking an
After taking time,
adjournment,
please.
that is not done.
Yes.
Yes. What is urgency for you?
No. Last case has been filed.
Huh?
I have filed the declaration injunction suit before the Honorable Civil Judge Senior Division, Ramdur, claiming the relief of declaration, permanent and the rectification of the instrument.
You have an interim order in this case?
Interim order, I have an interim order.
Yes. Please come. The
Already both parties
interim
have-
order earlier granted is extended until further orders. List this matter on February 12th. Yes. Next.
Seal number 50, enhancement. The second party.
Yes.
For petition, my lord, earlier occasion I made a suggestion that child is with the husband. For my lord, directly will get secured to the GNWC is filed. There is no GNWC is filed by wife seeking custody. Thereafter, my lord, the objections will not done. One petition is at Bangalore, my lord, one petition is at Bagalkot.
Now you're seeking this Bagalkot petition to be transferred
No,
to,
no, Bangalore to Bagalkot.
where did you stay?
Bagalkot.
That is the father along with the child.
Yes, yes.
Yes, we will do that.
No, she deciding at Bangalore.
What to do? He has to take care of the boy. You are not bothered about it. Let him be at, let
I
her.
am representing the husband and the child.
You are representing the husband.
Husband. I'm for.
No, so child is with the husband.
Yes,
Yes, child is with the husband.
Then we'll dismiss it.
she also deciding.
Permission, my lord, says she can contest the matter. Expenses.
Why should the? Already he is taking care of the expenses of the boy.
She is taking
Let
care
her,
of-
let it be. The present petition is filed. Seeking transfer of MC number 894 of 2024 pending on the file of the Principal Judge, Family Court Bangalore to Principal Judge, Family Court Bagalkot. The facts of the case are the marriage solemnized on 3/6/2013 at NWKRTC Kalyana Kendra, Hooghly. In the wedlock, they're blessed with a daughter. It is the case of the wife that she has been forcibly removed from the matrimonial home in the year 2020, and from there on, she is living with her parents. The husband has filed MC 25 of 2024 seeking divorce.
No, wife has.
Her wife has filed MC 25 of 2024 seeking divorce on the file of the Family Court Bagalkot on 12/2/2024. The husband had filed MC number 894 of 2024 under section 9 seeking restitution of conjugal rights on the Principal Judge Family Court at Bangalore. It is stated that the distance between Bagalkot and Bangalore is about 500 kilometers, and there is threat to the life of there is threat to the life of the wife, and it's difficult for her to travel. As such, the matter pending on the file of the Family Court Bangalore be transferred to Bagalkot. Next para, Land Council appearing for the petitioner by submits that considering the inconvenience being caused to the wife, the MC pending on the file of the Bangalore may be transferred to the Family Court at Bagalkot. Next para, Land Council appearing for the respondent, husband submits that husband is working in Bangalore. In fact, the daughter is with the father, and he has been taking care of the child. It is submitted that the mother has not taken any steps to the mother has completely neglected the child, and it is stated that no petition is filed by her seeking custody of the daughter. Considering the inconvenience that is to be caused to the husband who is working in Bangalore and the daughter who has to be taken care of by the father, the petition may be dismissed. It's fine. Having heard the counsels on either side, producer material on record. The wife and the husband are staying. The wife is staying at Bagalkot, husband at Bangalore.
She is also staying at Bangalore.
She is also.
Yes.
And then counsel for the respondent submits, counsel for the husband submits that, in fact, the wife is staying at Bangalore. but to harass the husband, she has filed such a petition. Next one. Considering the fact that the husband is staying in Bangalore and is taking care of the child, as such, the convenience of the father and the child needs to be given more importance and credence than to the convenience of the wife. In that view of the matter, this court finds no reasons to transfer and accordingly dismissed.
Dismiss.
Number 60. Petition statement.
Your Lordship, and the proper counsel representing the petition.
Aren't we both there?
Counsel of
Give it a respond.
the matter will be kept on Monday.
This matter, it is submitted with the counsel petition is unwell. This matter after vacation on 8th of January. Yes, next.
Lord, in this matter, I appear for respondent, Lord. Yesterday, Lord, I have tendered appearance. Lord, may I request it after vacation, Lord?
Any urgency? Interim order is there?
I think there is an interim order.
Response for the respondent. This is matter after vacation. Interim order earlier granted is extended till then. List on 11th of February.
Lord, let them serve one set of Lord entire papers.
Serve a set of papers on it. Also for the petitions to serve a set of huh? Huh?
This third one, but one second.
Any of these asking serve. Yeah.
Number 80.
This matter, there is one more connected civil religion petition. May I see both will be tagged along? This is against 7 to 11 application which was filed by me, and the other is against section 94.
You wanted this part of the vacation or after vacation?
Monday or Tuesday.
List it on Wednesday along with so and so. Yes, 19.
Number 90.
Defendant's revision petition. Challenging the application allowed in I number 1 on Rule 1(8) matters, permitting the plaintiffs to sue in representative capacity. The plaintiff itself discloses that they have independent and individual interest matters. For a moment, their prayer at page number 42 of the plaint may be seen. I am a tenderer, successful bidder. Work order has been
Let's
given.
see the order. Where is the order?
Order is at page number 12, my lords.
That is dismissed.
Well, I number 1 under order 1 rule 8 is allowed, my lords, and application order under 31(1)(2) has been dismissed, my lords. Against that, the plaintiffs referred MFA before this honorable court, and this honorable court has given an interim injunction. And in that, I have filed application for vacating of stay. My lords, my grievance is with respect to I number 1.
No, what is the implication of that order on this?
My lords,
No, by
Please.
representing, once this application is allowed,
the suit will be stayed, my lords.
no, not the suit will be stayed.
Please.
Injunction order is
Injunction,
granted.
my lords, that will be enforced, my lords, since
No, there, injunction is granted to whom?
injunction is granted in favor of the plaintiffs,
Plaintiff who is
Yes.
representing.
who have filed in a representative capacity.
Exactly.
Please.
So, when that is also part of this order has culminated into that order.
Please.
Once, first of all, step 1 is permitting them to represent by so and so.
Please.
Thereafter, MFA is, thereafter they sought for the injunction.
Please.
Injunction is granted. That is affirmed in the appeal.
No minutes. Injunction was refused initially by the trial court. The plaintiffs preferred an MFA.
That is granted. So
Temporarily.
what does it mean?
But
What does it mean? Court has permitted. Court has that.
The court, the MFA court while granting interim injunction has
That's
not.
pending. That is
It's pending. It's pending. I have tried
Then
my
this
side.
also go with that. What is the number?
MFA 105580 of 24 months.
List this matter along with MFA number so and so.
I'm seeking stay of the suit, Manoj. For a minute, I will only take 1 minute of
In
my life.
MFA, what you can't get, no, you will not get.
Manoj, I'm not seeking. Manoj, in MFA, I have filed vacating interim.
Just there because both the matters are listed. No, it will be like kind of chaos will be created with. In one hand, you have injunction, and the other hand, the court will say, No, you cannot, you can't, because you're the representative capacity, you cannot.
I am questioning the injunction, interim injunction order separately in the MFA.
Let the court decide. Whenever you want to list this matter along with so and so.
The matter and the MFA mallards that is listed on Thursday mallards.
Thursday, along with that on
My
Thursday.
cause of action under CRP would be is altogether different. Mallards, they
Then
are
the court
calling-
will decide, don't worry, Thursday,
Please.
along with so and so. Yes.
Still number 20.
Yes.
Your Lordship, representing the petitioner husband, Your Lordship.
How much is the amount granted?
Your Lordship, 9,000. And he is a coolie and he earns rupees 10,000, Your Lordship.
How much you are ready to pay?
Your Lordship, I am unable to maintain myself itself, Your Lordship.
You said you're earning 10,000, how much you're going to pay?
Your Lordship, I want to settle it in a one-time settlement. Your
Before
Lordship.
that, you will settle it. You have a child also.
Yes, Your Lordship. I want to give
5,000.
Your Lordship, so stay would be granted.
No, just like the stay would not be granted.
Your
You will pay
Lordship, the wife has filed a false complaint, Your Lordship, under 498.
So all those will not be considered. You have to pay some amount. If you otherwise you want to wait for it, will issue notice. Let them come. If you want stay, on condition.
Yes, Your Lordship.
Notice.
Your Lordship, at least 30% amount I will deposit, Your Lordship.
That was 3,000.
No, Your Lordship, 30% of the arrears, Your Lordship. It will come almost up to 90,000.
You will deposit.
Yes, Your Lordship.
When?
Within 2 weeks, Your Lordship.
Then counsel the petitioner submits that petition is a coolie and his income is 10,000 and court had granted 9,000 as maintenance and it's difficult for them, but for him to pay the amount of 10,000. It is submitted by the counsel that the petitioner is ready to deposit 90,000.
Yes, Your Lordship.
Is ready to. Shall I record that?
Yes, Your Lordship.
Is ready to deposit 90,000. Considering the submission, they shall be stay of all further proceedings on the condition that the petitioner shall deposit 90,000 within 2 weeks, or else the stay granted by this court shall stand vacated without further reference to the court. Yes, next. Notice to the respondents. Yes, next. 21.
Husband is a petitioner.
How much is granted?
15,000.
1.5.
Please.
What is his income?
No, it's a mechanic. It's not working as a laborer.
How much is going to pay?
Around 7,000.
Huh?
Yes, sir.
It is submitted that the court, without considering the capacity of the husband, has granted an amount of rupees 15,000. He submits that he is a coolie.
Please.
Coolie. What is his occupation?
Yeah, coolie is a mechanic.
He's a mechanic.
Yeah.
Considering the submissions, they shall be stay of all further proceedings on the condition that the petitioner shall continue to pay an amount of rupees 5,000 and the arrears continues to pay 7,000 and the arrears at 7,000 shall be paid within a period of 8 weeks from the date of receipt of the copy of the order. Either of it default order. Yes, next. Notice to the respondents. Yes, next. 22.
Kadur to Melody, Ranadilla, more than 3 particular kilometers.
Which year is MC? MC is which year?
24 minutes. 13/6/2024 minutes.
Please come. The present petition is filed. Seeking transfer of MC number 50 of 2024, pending on file of the senior civil judge at JMFC Kadur. To the second additional senior civil judge at JMFC Ranebenor. The facts of the case are the marriage has taken place. When is the marriage? On 8/9/2022. Any children?
No, madam.
And in view of it is stated that the respondent addicted to bad choices. And as such, the petitioner had to move from the matrimonial court. She has filed criminal miscellaneous number 335 of 2024, seeking maintenance on the file of the second additional senior civil judge and JMFC, Rane Benor. Husband has filed MC number 50 of 2024, seeking restitution of conjugal rights on the file of that is MC number 50 of 2024, on the file of the senior civil judge and JMFC Kadu. It is submitted that, by the land counsel for the petitioner that the distance between both the places is more than 340 kilometers and it's difficult for the wife to travel on each date of hearing. And further, as the criminal miscellaneous is already pending on the file of the family court at Rane Benor, on the file of the additional senior civil judge and JMFC Rane Benor, this matter also may be transferred. The notice is served on the respondents. No wakalat is filed on behalf of the respondents. Next, having heard the land counsel for the petitioner, there is a material on record concerning the fact that already criminal miscellaneous is pending on the file of the so and so, and the distance is more than 340 kilometers. This court deems it appropriate to pass a following order. The so and so pending on the file of so and so is withdrawn and transferred to so and so accordingly allowed. Yes, next.
Number 20.
MC is of which year?
Hello.
MC of which year?
2024.
From where to where?
From Hubli to Gadar,
Distance?
60 kilometers.
Please come. The present petition is filed seeking transfer of MC number 502 of 2024, pending on the file of the Principal Judge Family Court Hubli to Family Court Gadag. It is submitted that the distance between both the places is 60 kilometers. 60?
60 kilometers.
Yes, 60 kilometers, and it's difficult for the wife to travel. Considering the submission, they shall stay of all further proceedings in so and so, so and so. In the next date of hearing, petition is permitted to take out notice on the counsel, a hand summons on the counsel appearing to the respondent to the trial court. In addition, the district shall also issue notice to the respondent. This matter on 21st of January. Yes.
Number 24. Will be Masuki.
Well, slight petition to be transferred from Dharwad to government.
Says,
This is 92 kilometers.
and MC is of which year?
2024.
The petition is filed seeking transfer of MC number 33 of 2024, pending on the file of the senior civil judge and JMFC, Haveri to Principal Judge Dharwad. It is submitted at distances
92 kilometers.
92 kilometers, considering the same stay and notice, and in addition, same like in the earlier order, same date also, and summons on the same order, same date of hearing. Yes, next. Next.
Number 25.
The transfer of notes, the petition filed by transfer for resolution of notes marriage, which is pending before the family court at Belgaum, to the family court at Notes Hubli, where notes in petitioner's petition seeking for notes recovery of notes the maintenance amount is pending, which has been contested by notes, is being contested.
Which year is the MC?
24 notes.
Yes. The present petition is filed seeking transfer of MC number
194 of
MC number 194 of 2024, pending on the file of the Principal Judge Family Court at Belgavi to the Family Court at Hubli, where the petition filed by the wife, that is criminal miscellaneous number 45 of 2024, is pending. It is submitted that as already the respondent is appearing before the court at Hubli This case also may be transferred, considering the submissions. They shall be stay of all further proceedings. Same order, hand summons, notice, and date should be the same. Yes, next.
Fill number notice. Let us read that.
Yes,
This is wife's petition seeking transfer MC petition from Anekal to Jamkandi.
listen,
It's 580 kilometers.
580 kilometers. MC is of which year?
21.
21.
2021.
What are you doing till now?
Notice was initially not served, my lord. Recently.
Get the proceedings.
No, my lord. She is having a 7-year child.
Maybe. Where is it?
Page number 31.
Page number?
Page number 31.
Hmm.
Page number 37.
30?
7.
Hmm.
Just on 27/5/2024.
Hmm.
In the month of May of this year. Rejection.
You have filed only till 9. What is happening till 12? These proceedings are till 29. What is happening after that?
On 11th of this month, this matter was posted for cross of PW. Cross of
That means evidence has started.
evidence was just the chief examiner.
I mean, once the evidence has started, we will not transfer any of the cases.
One special petitioner having
Might be, what is she doing? What is she doing? Whenever she remembers and whenever she feels like she can't come to the court. And the judicial as officer has already spent some time on this case, and we can't waste the judicial time for your latches. I'm an administrative judge for these courts, and we have a standard pattern to dispose of the matters. And this kind of transfers can't be done. And we can't give any kind of inconvenience to judicial officers also. That also has to be considered. No lack of knowledge. Tell your client that it's going to be dismissed. List this matter on Monday. No, we'll keep it open. Like if you want, you can make an application before the court for your expenses, but not the transfer. Yes, Monday. Get it, sir. No. What for notice? Waste of time. Yes, 27.
Fill number 27. Gurushankar Moot.
Yes.
Wife's petition for transfer of MC case from Alagatti to Dharwad.
Distance.
90 kilometers.
When is the MC?
Next date is on 31. 2024.
2020. The counsel for the petitioner, the present petition is filed seeking transfer of OS number 227 of 2024. What is this OS?
For restitution of conjugal rights.
OS number 227 of 2024, pending before the civil judge at JMFC at Kalgatti to the JMFC court at Nargul.
At Nargul.
Nargul. It is submitted that the distance is
90 kilometers.
90 kilometers, and it's difficult for the wife to travel. Considering the submission, same state, date also same, hand summons, yes, and also notice by the court. Yes, next.
Preliminary hearing matter. Fill number 28.
Yes.
Below note.
The wife's petition laws. When she has filed an application at section 151 of CPC, seeking stay of further proceedings in MC number 102 of 2014, wherein the arrears of maintenance is balance of rupees 3,08,000.
That is dismissed by the court.
By PCC report.
Let's see the order.
Yes, at page number 30.
Page number?
13 now. Order start now. Reasoning at page number 15 and 12.
Page number?
15, 16 is the reasoning.
You mean to say 1-3?
Please, one.
You have filed criminal miscellaneous number 22 of 2024. What has happened to that?
He has not appeared. Therefore, I filed an application. Though he is appeared in the another case, he is not appeared before
The
this.
present revision is filed. Agreed with orders passed in I number 8 in MC number 102 of 2023. The husband has filed the MC seeking divorce, and the wife had filed the criminal miscellaneous seeking seeking maintenance, and the court has granted maintenance. When the husband has failed to pay the maintenance, wife had initiated the recovery proceedings. It is a case of the wife that the husband is not appearing in the recovery proceedings, and he is contesting the divorce petition filed, MC filed, seeking divorce. At that point of time, this IA came to be filed, seeking stay of all further proceedings till the maintenance amount is paid. That came to be dismissed by the court. Next para. Though the husband wants an order from the court, and he was proceeding with the divorce proceedings, and when an order is passed by the court giving maintenance, that order he is not complying with, in spite of any other remedy that is available to the wife, but still the husband cannot take advantage of the procedural law and deny maintenance to the wife. In that view of the matter, there shall be stay of all further proceedings in MC number 102 of 2023 till the next date of hearing. Petition is permitted to take out hand summons, then notice from the registry. List this matter on 27th of January. Yes, next.
Number 29, local.
Challenging the order on I number 2, seeking interim maintenance. Lord, on the ground that the respondent wife has already got married with another person, and 12 cases have been initiated against her first husband. And my Lord, she is
You are appearing for whom?
husband. The respondent wife, already before the marriage, Lord, with the present petitioner, she is married to one Rajsekhar, and already 12 criminal misdemeanors have been filed against him, and she is getting maintenance, Lord, 7,500. Suppressing all these facts, she got married with the present petitioner, and present petitioner has also filed a petition seeking nullity of marriage. Now,
and according to you, the first marriage is still subsisting.
Suppressed and
subsisting.
Subsisting. And she is getting maintenance from the earlier husband, 7,500.
And where is the discussion on that? In the order?
Absolutely, there is no discussion.
Where is your petition saying all this?
I have filed petition, Annexure G, page 57. Complaint has been lodged.
It is not the complaint.
Yes.
What is, how, in what form you presented all this before the court?
I have filed objections to the main.
Where is that? That we will read, that will look at.
Lord, my objections, page number 43, para 20.
40?
43, para 20. The respondent submits that the petitioner is an habitual offender who is involved in cheating people by marrying multiple times. The case filed by the petitioner in this regard are the proof for that. The petitioner is not.
That is not discussed by the court.
Absolutely no discussion.
The petitioner is agreed with the orders passed in I number 2, whereby the court had granted maintenance of
4,000.
4,000.
Yes.
Whereby the court had granted maintenance of an amount of rupees 4,000 per month. It is submitted that during the subsistence of the first marriage, the respondent has married the petitioner, and she is also getting the maintenance from the first husband. Though all these facts are stated that were not considered by the court, this court, having perused the order of the court and the objections that are filed, they shall be stay of all further proceedings. Pursuant to the order dated so and so. The petitioner hand summons and the court notice. This is matter on 20th of January. Next.
Number 30.
Husband petition.
I think yesterday I asked you to find out whether he is paying the 10,000.
Already has paid more than 75,000.
That means how much?
Yes,
I think we are talking about 10,000 per month.
7,000 for monthly maintenance in
When is it awarded?
27/5/2022.
27?
5/2022.
27/5/2022. So from there on, no arrears.
Yes, please. Already we have paid 75,000.
7,500.
Yes, please.
If you paid 70,000, you must have paid for 10,000, 10 months. What about the other months?
Remaining we have to pay.
That's what
Yes, please, ma'am.
we'll say. They shall be stay on the condition that you pay 7,500 per month and continue to pay 7,500, and whatever are the arrears at 7,500 till now shall be cleared within a period of 8 weeks.
Next date of, we will pay the next date of.
You just can't tell all this. You have to get instructions from your client. Call your client and find out that the stay will be granted. Mr. Counsel, listen to the court.
My lord, in criminal business 115/2023, my lord, he has paid 78,000 as per the instruction of his counsel. He has paid 78,000 in the recovery suit. So remaining amount he will pay.
Now, if the order is passed by the court, if your client can't pay, that's a difficulty, is it not? So, tell your client that 7,500 per month, he shall continue to pay. And from the date of petition till now, at 7,500, arrears should be paid within 8 weeks. I'll just pass over, get instructions, I'll pass an order. Yes. Next. Yes, if it is, list is completed, let it be in the favor. Yes.
Heard this matter 3 weeks ago. That's a petition.
No, that's a whole difficulty. Every time another 1 hour for the matters, whenever it's adjourned. What are these matters?
Petition challenging the rejection of the application and order 7 Rule 11, seeking rejection of the petition. The main ground is that the cause of action is not disclosed in the plea.
Yes, that is about the defamation one.
Yes, yes, injunction.
Yes.
Please, Lords, along with the plaint, Lords, there are many documents have been produced, Lords, showing whether defendants have published defamatory posts on the social.
You might place 101 documents. Any amount of proof without pleading is of no use.
Lords, there is pleading that defendants have been.
When and where?
Lords,
That should say.
Since, Lords, it's continued. Every day, Lords, more than 100 posts are being published. Lords, to mention all that, it is impossible.
You can even say that every day, like that there is no averment of that nature.
Lords, along with the plaint, more than Lords, 500 documents are produced. Lords, 4 bunches of documents have been produced. Along with plaint, Lords, showing which defendant, Lords, has been posting what on social media. And Lords, while considering the application.
What is the difficulty in saying that every day they are posting messages running into hundreds or 500s or whatever you're saying? Isn't it? Parties are bound by their pleadings.
Please, I agree, Lords.
You show to the court 100 documents and you don't plead anything. Can the court look into all that?
Lords, the details of the posts are not pleaded.
However, not each and every detail. No, please, let's come to your plaint. Please come to the plaint. Please read
May I read from the beginning, Lords?
Para number 6, that's where you start saying about what has been done by them.
Para 5 minutes may I start.
Read.
That His Holiness Sri Sri Raghaveshwara Bharati Swamiji is discharging his responsibilities as a Pitadipati of the said mutt in a very fair, transparent and diligent manner. That being the case, some of the members belonging to Havyaka Brahmins community conspired to dethrone His Holiness Sri Sri Raghaveshwara Bharati Swamiji as Mathadipati of the said mutt.
and hatched vicious plans to take over the mutt and misuse the funds of the said mutt for their private ends. His Holiness Sri Raghaveshwar Bharati Swamiji, who was falsely implicated by one lady on vexatious and baseless charges of rape in Girinagar Police Station, Bangalore, which was committed as SC number so-and-so before the District and Sessions Judge at Bangalore, and His Holiness Sri Raghaveshwar Bharati Swamiji was discharged as innocent, and all allegations and false evidence collected in the case were held to be baseless and vexatious. Taking this opportunity, the fringe group in Havyaka Brahmins community have made and are making every possible efforts to tarnish image of the said mutt in general and image of His Holiness Sri Raghaveshwar Bharati Swamiji in particular. The other defendants are some of the people belonging to such fringe group and are making venomous attempts in distorting the character and image of Holiness Sri Raghaveshwar Bharati Swamiji. The plaintiffs herein are deeply hurt and pained by the publication of false information circulated by the defendants herein through print and social media. That the allegations and venomous campaign undertaken by the defendants herein to denigrate the image and authority of His Holiness Sri Raghaveshwar Bharati Swamiji and the said mutt are unpardonable and go a long way in hurting emotional bondage of the plaintiffs with the said mutt and Swamiji, and create irreparable damage to the feelings and faith of innumerable followers and devotees of the said mutt. The plaintiffs see divinity and total sanctity in said mutt and His Holiness Sri Raghaveshwar Bharati Swamiji, and they are unable to withstand the disrespect shown by the defendants herein by defaming the mutt and His Holiness Sri Raghaveshwar Bharati Swamiji. The defendants herein have caused immense mental trauma and emotional dilemma to the plaintiffs. Defendants herein have stirred the faith and belief of the plaintiffs reposed on the said mutt and Holiness Sri Raghaveshwar Bharati Swamiji. The defendants are constantly indulging in baseless and unreasonable allegations and claims in print and social media, even after His Holiness Sri Raghaveshwar Bharati Swamiji got acquitted or discharged in the false rape case. That the defendants are misusing platform of print and social media to spread false information about the said mutt and His Holiness Sri Raghaveshwar Bharati Swamiji, and they're continuously engaging thousands of devotees and persuading them to show disrespect and defame His Holiness Sri Raghaveshwar Bharati Swamiji. The acts of defendants are highly dangerous and hit at the root and establishment of said mutt, and defendants ought to be restrained from indulging in this kind of poisonous campaign against the said mutt and His Holiness Sri Raghaveshwar Bharati Swamiji. If his image is shattered, the reputation of the entire Ramachandrapura mutt itself will come tumbling down, impacting lives of thousands of devotees, believers, animals under the care and shelter of the said mutt. Defendants are also bad-mouthing about the mutt and His Holiness Sri Raghaveshwar Bharati Swamiji among the people belonging to different communities, castes, who are followers of the said mutt. This act of the defendants need to be curbed at the earliest before further damage is caused to the image of the said mutt and His Holiness Sri Raghaveshwar Bharati Swamiji. These are the contentions. Producing some documents, which are produced along with the plaint, as a sample. However, 4 different bunches of documents have been produced by the plaintiffs. CRP 100182. There are various posts, posted by the defendants on the social media.
What is the name of this petitioner? Balakrishna Raja Nichal.
I have tried to take out the posts posted by some of the defendants here. It was difficult.
It also Shankar Bhatt is in the next matter.
It is not shown.
So something is shown as Shankar Bhatt. All the posts shared by Shankar Bhatt.
Shankar Bhatt, please.
Is he the next?
He is in 100182, my lords.
Is the petitioner in the next case Shankar Bhatt?
Please, in 182, my lords. He is one of the defendants, my lords.
In which case?
So many defendants, Lord. In fact, in first petition, there are altogether 11 defendants. But
Shankar Bhatt is defendant number 7 in OS number 69.
Shankar, what is this?
Defendant number 7 in OS number.
No, let us say, as far as this petition is concerned, what are there? No, even,
Yes, sir.
no.
There are
thing
documents.
is, now what will happen is, now as far as you are concerned, that's particular petitioner, we can't now reject the plaint partially.
No, I'm not saying that. Lord, it's a certain position of law that as far as rejection of plaint is concerned, averments in the plaint is material.
Averments in the
Documents
plaint-
or written statement contentions will not be
No, no,
material.
we can also look at the documents that are filed along with the plaint while deciding the case.
Lord, nothing is stated in the plaint. In which media, is it print media or visual media, social media, print, social, everything is stated. At what point of time? What is the allegation made? By which defendant?
No.
Whether all defendants together have made
No,
the-
do you agree on the point that while rejecting the plaint, the court can look into the plaint as well as the documents that are filed along with the plaint?
Lord, my respectful submission is, as Lordship pointed out, any amount of evidence
No.
without
No, let's-
needs to be expunged.
No.
Without needs to be
Let's-
expunged
let's-
is the first point.
Let's
Second
go.
is, my lord, only because Order 7 mandates that plaint must disclose clear cause of action. Even vague and ambiguous cause of action is not maintainable. The thing is, and whether cause of action is joined, if that is so, under Order 2, Rule 4, they must take the permission of the court, jointer of cause of action. They can't file a suit against all defendants. Because one defendant has posted in one media on such and such a date. Another defendant independently has posted in another media.
How many defendants are there?
11 defendants. How cause of action can be joined, my lord?
That's
So you
far
should
as.
read, is it not, not that you don't have the paper and the.
Yes, I agree, my lord, since there are a lot of posts, my lord, it is impossible.
No, but you have made specifically so and so as defendants. When the plaint is drafted, you will say defendant number 1 has done so and so, so and so. Defendant number you may not say, for example, defendant number 1 has posted 100 posts. Not necessarily that everything should be mentioned in the plaint, but you can as well say defendant number 1 is so and so. He has posted this defamatory publication in so and so, and he continued to do several times. Defendant number 2, he did so. Defendant number 3, 1, and so many times it was published. Nothing. Then how can you make out a cause of action against the defendants?
Let's plaint along with the documents, my lords, if they are read in conjunction. Lords, there's a clear case made out against the defendants, my lords.
It's not. That's not the way how you can look at it. Your pleadings are important.
Please, my lords, there's a pleading that they are making defamatory.
Who is making?
Lords, defendants on those documents.
Defendants are not one. Defendants are several.
Please.
What each one of them? No, without a pleading, tomorrow they have to file a written statement to your pleadings.
Lords, they've already filed a written statement.
I'm telling you,
Please,
what will they say? What they can say? Because there are no specific governments. There are no specific governments against any of the specific allegations against any of the defendant.
Lords, insofar as this is concerned, my lords, since there are many documents, it ought to have been, my lords.
So, are you trying to submit that without taking any pleadings? If I just annex the documents, that would be sufficient. No.
Lords, my humble submission is that there are pleadings that, my lords, they are making
For
defamatory posts.
example, you are the defendant. No, you are the defendant. You are the defendant. You will file a written statement to the documents, or you will file a written statement as per the averments of the plaint.
Lords, I agree it is filed to the averments. However, my lords, while considering an application under 7 Rule 11, lords,
First of all,
documents.
First of all, no, as far as the defendants are concerned, where is the cause of action? Where is your plaint discloses it? Court looking at the documents while rejecting the plaint is on a different footing than your cause of action for filing the suit. That the whole plaint is a bundle of facts. Those bundle of facts should contain.
Lords, my humble submission is that only the details are not forthcoming in the plaint.
That
Lords,
is
it's
what
a
is
curable-
important. I can understand this is one defendant. You're filed a suit against n number of people. And you should say, why are they parties to the suit? What did they do specifically?
Lords,
Now, what the court will do? Can you expand beyond your pleadings?
That's insofar as the application for rejection of plaint is concerned, my lords. My humble submission is that documents come to my aid, my lords. Since they clearly depict which defendant has been
So
posting
does
what.
it mean that you will file the documents and keep quiet? Plaint do not contain the averments.
Lords, they contain the general averments, my lords. However,
There
specific
cannot be
averments.
general averment. There should be a specific averment. Plaint is your case. There should be a specific averment. Who has done what? Court will not read around. Court will look into, now tomorrow you might file 100 documents. Court will look at your pleadings. Now one party cannot be permitted to traverse beyond the pleadings. And any amount of evidence that is placed without there being a pleading is of no use to the plaintiff.
If the documents are perused, my lords, it is clearly, my lords, evident that they have been
That's not
continuing
the,
to, my
that's
lords.
not, that's not the law. That's not the law.
That's
It's
my
for you, that's your case. That's for you to know where, as far as looking at the document while rejecting the plaint, that is a different issue. In what context that will come? For example, you are seeking a specific performance of an agreement of sale. Along with that, you will file agreement of sale. Then the court will look at the agreement of sale for any other practical purposes. Doesn't mean that you will not take any pleading that there is an agreement of sale and the court will look at the agreement of sale. No, it's not like that. That proposition which you are relying upon, saying that the documents filed along with the plaint have to be seen, can also be seen or not in this context. I'm saying that is there. Plaint, you have to look at the document, not that without there being a pleading. In pleading consonance with the pleadings, any documents are filed, that we will see.
That's that. My humble submission is that, my lords, since specific, my lords, contentions are not.
You have not raised. You don't even know who are the defendants.
My lords, only the persons who have made those posts. Only those people are made as defendants.
It is not. It is your case. You have to make out a case, not that something like as if like a hearsay evidence. Plaint can't be drafted.
Lords, it's a curable defect, my lords.
How will you cure? You would have cured it long back by seeking amendment to the plaint. That you did not do.
Lords, initially they don't file this application. After 5 years, when the matter is posted for evidence, they will not. They're contesting the matter by filing a detailed written statement, my lords. It is also enclosed. And when the matter is, my lords, posted for evidence, my lords, at that stage they have filed this. It's only an afterthought, my lords. Why did they keep quiet?
Order 7 Rule 11 petition is filed. After the trial has commenced,
No,
why
before trial. Trial has not commenced. Trial has not commenced. And you have taken a specific contention.
Why is she taking, what is its submission?
My lords, it was, suit was filed, my lords, on 25/4/2017 as per their own synopsis. My lords, they filed written statement on 26/2017. On 11/8/2018, the matter was posted for evidence, my lords. And this application has been filed after 1.5 year after the Millard's stage on 22/10/2019. After 1.5 year of matter being posted for evidence.
Issues are same.
Please.
What are the issues?
No, sir.
Let's see from the order the learned might have discussed about that. Where is the order? Include order.
Order, page 59, page 61, next sheet.
$60?
61. About the main reason assigned to the trial judge is whether cause of action is award or not is to be decided along with in the main suit and not at this stage. That is what the reasoning given. My specific contention was which defendant has made publication on which day. Whether all defendants together made publication or they made independent publications. If that is so, cause of action cannot be joined unless court permits. They have to file a separate suit against all defendants. Even if the documents are proved, all defendants together have not made any publication. all dependents have made independent publications. Order 2, rule 4, they have to take permission. So under order 7, rule 11B also, Plaint deserves to be rejected. That's my, one of the ground.
That can't be a ground for rejection of the plaint, my lords.
But it's barred by any other law.
My lords, that's a curable defect, my lords, seeking for permission. My lords, that can't be a ground to reject the
You will
plaint
not seek
under
the
order
permission at
7.
the time of trial.
That can't be a ground, my lords, it is my submission. That to reject
No, you
plaint.
answer to the first ground.
Please.
You answer to the first ground. Where is the cause of action for all the defendants? Who are the defendants? Nothing. You don't even name them. Defendant number 1 did this. Defendant number 2 did this.
Lords, all of them have been, lords,
No, I think
engaging in post.
we have already, like, you have submitted your arguments. Court is not convinced with that.
That's, in that event, my lords, I may be permitted to withdraw the suit with liberty to file fresh suit, my lords. Since, my lords,
Injunction can be filed at any time. Recurring cause of action.
on the same cause of action, my lords, since the suit is filed, my lords, in the 2017, and all the documents are, my lords, from that year itself, which have been produced along with the plaint, my lords.
I am not sufficient of the.
Why you stop doing all that later? No, I'm asking all these. They are seeking a liberty to file a fresh suit on the same cause of action. You're saying that the suit injunction can be filed at any time whenever there is a cause of action. I'm saying that you stop doing that. Defamation messages. Now your clients have stopped now.
Yes. No, they were making fair criticisms. They were making fair criticisms about the conduct of the pontiff. That's what they were doing.
Yes.
And kindly see page 72, madam. Last paragraph.
No, but your plaint can't be so casual like this. That too, when there are, I can understand one defendant. You made so many people as defendants. You don't tell them what are they doing. And as you rightly said, you should have asked, like, when you're filing a suit against so many of them for the same cause of action, different causes of action.
May be permitted to withdraw the suit with liberty to file fresh suit, my lords.
And only say that it's not permissible. I give it to lordship. According to me, it's not permissible.
Why? What you have done. It's a technical defect. Like they have, as rightly said by her, they have already filed the documents.
From my submission is whether it's a simple suit for injunction. There is no limitation at all.
No, but what will happen is, for the same cause of action, unless and until liberty is given by the court, they cannot file a suit, fresh suit. The only problem in this is, plaint is not disclosing the cause of action, and everything remains to be the same. Then give them the liberty.
My other submission is not permissible. After 5 years, now we are seeking differently. Even the application.
And you also contest after 17. When did you file this IA?
19.
You also kept quiet for so many years.
But my Lord, Apex Court says, even at the fag end of the trial, an application can under order 7 to 11 can be considered. That's what the Supreme Court says. And there is also another ground, my Lord, which I have urged, not only 711A, and another ground is 711B, because I have taken up another ground. Under section 41J of the Specific Relief Act, there is a bar, because it says that section 41J says injunction cannot be granted when plaintiff has no personal interest in the matter. These allegations are not made against.
No, but here, under the Endowment Act, there is he is a person interested.
No, the allegations were made against.
Correct.
He says
Correct.
against money.
No,
The
it
allegations are against politics.
is a charitable institution, and he is a person interested. If I don't know which provision of the Endowment Act says, as per the section 218 of the Andhra Pradesh Charitable Endowment Act, it's an interested person. No, you cannot.
Yeah,
You
in
can't.
Karnataka, mutts are excluded from this religious.
They don't fall.
They don't.
What do you say on that?
Lords, their application may kindly be perused, my lords.
That ground is not taken.
That ground is not taken. My lords, it is filed only under Order 7 Rule 11A, my lords. for not disclosing cause of action.
No, it is also, that ground is
Where
also.
is that? Let's see.
That ground is also.
Your application is where?
Page number 62, my lords.
56.
50?
This is Annex C.
Where did you say so? Further, the alleged document plaintiff has relied upon the real cause of action and how the alleged document refers only so and so. Such extent, the plaintiff cannot maintain suit against us.
In arguments, they are taken up that context. Supporting the pedal.
Where is that?
They have stressed on cause of action.
Where do you have that written documents?
Yes.
Pass on.
Page 3, para 5. Page 3, para 5. Extracted section 41J.
What do you say?
Let's firstly, their application does not disclose, my lords, this ground. It is filed only under Order 7 Rule 11A, my lords, for not disclosing the cause of action. It is not filed under Order 7 Rule 11D, my lords, for the plaint being barred under any law. Further, my lords, when my lords, on one hand, they cannot insist that the plaint, my lords, be specific in pleading, my lords, regarding cause of action, and on the other hand, without pleading, my lords, a ground in their application, they cannot, my lords, raise that ground, my lords, before this court, or my lords, even before the trial court. My lords, even my lords, considering that ground, my lords, it's a matter of trial whether I'm an interested person or not, my lords, in order to file a suit for the injunction, my lords. It can't be
There is
considered, my
nothing
lords.
there because defamation is not against you.
My lords, this is a suit for bare injunction, my lords.
That's what.
Seeking to restrain them, my lords, from not publishing
Know
the.
that the person against whom the defamation statement is made, he will file.
Lords, we are the respondents, my lords, plaintiffs are the devotees and followers of the said matter, my lords.
No,
And whether they are interested, my lords, my lords, it's a matter of interpretation and trial, my lords. So whether they can be construed to be interested persons under that provision or not, and it can't be decided, my lords.
Affected persons. Yes. Will allow.
With liberty, my lords, to file fresh suit on the same cause of action.
No, in that case, every time a plaint is rejected and they make about a cause of action, and in every case the court starts saying that you have a liberty to file a fresh suit.
That's
Then what
only
is the
because
purpose?
even in their application they say that they refer to the documents along with the plaint as well. They say that even the documents produced along with the plaint do not make out a cause of action. However, that is not correct. The documents are very clear, my lords, and they admit the production of those documents.
Like both of you cannot say anything which is now Order 7 Rule 11 petition. Now we are looking at the cause of action. Cause of action should contain looking at the entire pleadings of yours. May not be at the caption of cause of action. It doesn't disclose. Again, there's so many defendants. On that ground, we'll dismiss and will not grant any liberty. Please come. The agreed with the orders passed. Right? I number 3, invoice number 16 of 2017, dated 30th August 2023. The defendant number
9.
Defendant number 9 is before this court. The suit is filed seeking the relief or permanent injunction against the defendants or their agents or anybody under or through them from publishing any message or statement of article, either in print or in television or in social media, via Facebook, WhatsApp, Twitter, Instagram, etc., against Ramachandrapura Mutt or His Holiness Sri Raghavendra Bharati Swamiji in future. It is the case of the plaintiffs that the defendants who are running or defendants 1 to 11 are making defamatory statements against the Swamiji. It is they are denigrating the image and authority of the said Swamiji, and the plaintiff being the devotee is affected by the said statements made by the defendants. It is stated that the defendants are misusing the platform of print and social media to spread the false information about the Swamiji, and they are persuading them to show disrespect and defame him. The act of defendants are highly dangerous and hits at the root and establishment of the
Apologies for my intervention, my lords. And instructions are that, my lords, I'll file an application for withdrawal of the suit, my lords, with liberty under Order 23, Rule 1, my lords. That may be considered, my lords. Matter may be taken up next week. On Monday or Tuesday, my lords.
Then we'll pass an order. The business matter on the top of the list on Tuesday. Yes. Okay. Yes.
Number 32.
Previous occasions, negotiations were made, but the matter could not be settled. The wife's petition seeking enhancement of interim maintenance plus.
How much is that?
8,000 is granted by the family court.
How much is the income of the husband?
As per the wife, it is 75,000 because he works in.
No, as per the evidence.
That's,
As per the evidence.
As per the evidence, he in his objections has stated that net salary is 56,000, and plus he has also agricultural and rental income.
Then why not it be increased?
Now what has happened is, after the order that came to be passed, quite prior to that, Lord's divorce petition was filed by the husband, and decree of divorce came to be passed.
Alimony is not granted.
No, for 1 year, Lord's, she did not take any steps. Now she has preferred an appeal before the High Court, and Lord's, I am told that she has taken some orders. But however, after the expiration of the appeal period, he has already Lord's contacted second marriage. Currently, Lord's is married now. He is having the wife, second wife. And now the situation is like this, Lord's. That's the reason I told my learned friend to, once for all, we shall put an end to this litigation. So,
No, why don't people appear before the mediation?
The husband suggested that he will pay 5 lakhs and that's that.
How can it be? 5 lakh, how can, no, you didn't, you have taken divorce, you didn't even pay permanent alimony to the wife. And you say 5,000,
No.
very unreasonable, 5 lakhs, very unreasonable.
the option was given to them itself. Let them come with a proposal, so that I can Lord's convince my party. Lord's,
No, let both the parties appear before the mediation. Mediation center, that's better. It is submitted that already the respondent husband has contracted the second marriage, and the husband is interested for a one-time settlement. Both the parties shall appear before the mediation when?
January, any day.
On
Second.
On 15th of January.
Correct.
Yes.
Number 33 and number 34.
Yes, what has happened to this?
Yes, I have filed my additional statement of objections stating that my lord has directed me to what is the distance between the, it is a 200 meter. It is beyond.
Then why you people are doing all this? Act says
It
100
is in the
meters.
interest of public. It is in the interest of
No,
public.
you cannot do anything in interest when contrary to your own
Because
act.
the villagers and the persons who are traveling in
So the
that road.
fact remains is it is 200 meters. That is not within the prohibited distance.
Beyond 100.
100 meters is there. 100 meters is the prohibited. But it is under 200 meters that
So
distance.
then we will allow as a petition.
Then I will leave to Lordship.
Where is that additional statement?
Please, I have filed on the 10th of December.
Code officer, look at it.
In 2015 itself, they have conducted a survey and they have given report.
Under which provision that beyond 100 meters, if it is the distance is not more than 100, I mean within 100, still, if it is more than 100 also, you can pass such an order. Is there any provision in
No,
that?
under 5.4 in the interest of public,
That is distance is mentioned.
yes,
That is distance is mentioned.
they have not.
Is there any other provision in the act
No.
which says
No.
that a public interest has to be looked into even if it is more than the prohibited distance?
No, as per section 5 sub clause 4,
That too that I know.
if it's come to the knowledge of the deputy commissioner, he can issue the so-called notice, then he has to pass an order.
5, let's see.
Yeah. It says General Rules 1967. Five sub clause 4, madam.
5,
5 sub clause 4.
subclause 4.
Please. 5 is restricted in respect of location of shops.
The deputy commissioner may.
Please.
Please read.
The deputy commissioner may by order, after giving the licensee an opportunity of being heard, direct such licensee to sit the location of any shop, subclause A, madam, with a view to secure the convenience, morality, tranquility, decency of or safety of the public. In this matter, safety of the public is involved, madam.
So, Mr. Counsel, no, this you have to read 4. It is independent. Irrespective of the distance, under the circumstances, if the deputy commissioner feels that it is in the interest of the public, then he can take a call. That power is vested with him.
Yes.
No submission. The deputy commissioner has issued a notice stating that since there is objections and some of the places are situated within the prescribed limits, madam. And thereafter,
Let's see that notice. Page number.
That's why the Honorable Tribunal has directed him to give reply for that, but he has not produced that document before this Honorable Court.
Where is that? Where is the
He has
reply?
not produced it. Represented. The Honorable Tribunal has directed.
Now
him
let's
to-
see what is the notice given to you, given
Yes.
to him.
Yes.
Dated 17/8/2020.
yes,
What?
endorsement.
What did they say?
Where it says that my license period is completed on 30th, 6,
No,
2020.
in that entire
Yes.
that endorsement, please show to the court where they mention that that is situated within the prohibited.
In last paragraph, it states, in last paragraph, page 24, it states that it is located in a Nirapekshana objectionable area. It was situated. Hence, you have to sit. And the-
Restricted area,
Please,
prohibited area.
Prohibited area. Hence, the officer has.
So, in the light of, if that's the only reason
Yes.
for you to give a notice, now in the light of this, that it is more than 100 meters,
Yes.
then it has to go.
And they have specifically mentioned 5 subclass 4. It is the discretionary power of the deputy commissioner
There are
in the
two
interest of
different-
public.
No, two different things. First of all, though it is not within the prohibited distance, but still in the interest of public, if you feel,
Yes.
it is a different aspect.
Yes.
But in this notice, you specifically mentioned that that is within the prohibited area.
Yes, that notice is there at Annexure B, madam.
Page number.
I-
You don't have the papers?
12, madam.
In this minute, my junior has taken the file and
You take the papers. This is matter on Tuesday. Wednesday, and please come with specific instructions about
I have
whether, no, thing is, whether your argument whether it is within the prohibited, on the reason that within 100 meters, you have given the notice.
Yes, please.
No, when you have given notice under that aspect, when it is beyond 100, can you independently now exercise FIFO? That's the issue.
Please.
Yes.
And furthermore, for the last 22 years, I am doing the business in the very same premise.
Wednesday,
None of the
Wednesday at the request of Government
It was direct.
Yes, next.
interim order.
Interim order is extended till then Wednesday. Yes, next.
For 35, that's number 36. This will come up.
Who appears 36?
Which is
No representation. This is matter after vacation.
Please, my lord. On the petitioner. Item 36.
After that, in the earlier
I'm-
matter.
Item 36, my lord.
Yes. One minute.
Please.
February? February 3rd. February 3rd. Yes, which matter? No. 30, next is 36.
36, I am appealing for petitioner.
Yes.
In this case, the father of the petitioner
Hmm.
was the Benami.
1 minute.
Please.
Karnataka is saying something.
In
Yes.
this matter, I have a direction to file a statement of objection. My lord has directed in the last 8 days back. Till today, I have not secured any documents. I will file my statement. In last occasion also, on the same reasons, I have taken adjournment. I have not.
So the request of the government.
But what I can submit is that, my lord, the auction notification is questioned. That event has not taken place. Now they have to start the question.
The government will take receipt time. This is matter on January 21st. Yes. Next.
One submission is that, my lord,
Yes.
may not be necessary because that particular event has not taken place, which is sought for in the writ petition. Auction notification, connection is.
Your filing. Yes. 37.
Yes.
Husband's petition was the order dated.
Where is the respondent? Oh, you're here. Yes.
Order dated 7/2/2024.
Petition is filed by?
Husband works.
Ah.
The order of granting interim maintenance.
How much?
Looks 20,000 is granted. The short
What is your income?
looks my humble submission before going on to the merits of the case notes. Without there being an application for interim maintenance, the court has granted sumo templates. That is called in question. There is no provision which empowers the magistrate to grant.
Yes.
Order before passing the order.
No, it's for you to ask for maintenance and you don't want maintenance. What is this hurry of the court?
Order, kindly consider the given order that the trial court has gone into the contents of the entire petition. The
No,
contents
it's
of
not
the
that.
petition itself was.
We are on the IA. No, unless and until there is an application by the party.
The main petition itself was considered to be more the interim application.
Why
Because
should the court
contents-
consider? Where is the provision? Again, no, the courts on its own will consider the IAs without there being any application.
Not for
No, it is
disposal.
it is for you to ask the court that I want interim maintenance. If you don't want, you don't file an application. What is the anxiety and the consideration of the court on this?
On the 125, one more. Second proviso, the maintenance was granted. There, there is no contemplation of filing any application. Second proviso.
In that case, no, from now onwards, no applications are required. Court will do on their own.
Not court further.
Now, when an application is filed,
Not the procedure is not that the summary procedure is followed. Strict proof of not procedure law need not be followed, my lord. But there was evidence in the form of examination chief of the petitioner. There were objections for it. And there was even not main petition. All these were considered.
No, it is like this. First of all, you have to tell the court what is your requirement. What do you want?
Right.
What do you want? And once you say that what you want, then the other side will get an opportunity to say that I'm not in a position to pay or you don't require that much of amount. And there is an inquiry that is required. It's a basic thing. No procedure has to tell that. Even if the procedure is silent on that, that is what is required to be done.
Order. On the date when the order was passed, respondent's representation was husband's representation was not there for the last 1 year now. And even my lord, when the evidence exam chief was led for 4 months prior to that, my lord.
When you have not filed an application for interim maintenance,
The trial court
that
has
means
itself
you don't
made up its
require
mind to grant the maintenance for. That is why, Lord, I say.
File an application. File an application.
Somebody
We'll ask the
procedure.
court to decide it within 2 months. We'll ask the court to decide it within 2 months. It can't be without an opportunity. They can't do it.
There are no arrears of more than 2,50,000.
When the order itself is bad, the question of considering the arrears won't
Lord,
arise.
kindly consider more the interim order. Lord.
Yes, let's
It
see.
is at page number 53, my lord. Lord, and the first term, Lord, husband's Lord, occupation was considered. He was a senior software engineer. Secondly, the pleadings of the respondent does indicate that the respondent does not dispute his marital relationship with the first petitioner and the biological relationship with the second petitioner regarding status. Then third, my lord, the matter is set down now for cross-examination of PW1. Since the month of January 24, respondent.
Now the criminal miscellaneous is filed when?
What?
Criminal miscellaneous is filed on 2023. When is this order passed?
Order is passed on 7th
7
February
2024.
24.
Let the court finally decide now. Now that interim stage has gone. Let the court decide it finally, and you also didn't want the interim maintenance.
Lord, kindly understand. I was definitely in need, my lord.
And why did you
The
not file?
date, my lord, on which the order was passed, he had gone to Mecca.
That was
The respondent along with his mother.
No, please understand and answer to the court. If you are in need of it, where is the IA?
Lord, that is why I went to the court, my lord, and led my evidence, my lord, 4 months prior to that. Then I kept on attending the court, even at the cost of, my lord, payment of cost, my lord, the matter was urgent. Even then it ignored, it did not lead the evidence, my lord. Court then itself, my lord, so moto framed its mind, my lord, to grant, my lord, maintenance to the
In the
wife.
considered opinion of this court, such framing of mind is not proper. If he is not doing anything, it could have allowed the main application itself. If he is not cooperating, it could have allowed the main application.
Because he was represented by the lawyer, my lord. Lawyer was there, my lord.
That's what, giving an
So he
opportunity
would-
if they are not cross-examining, because we cannot go by to these kind of
He could have
procedures.
cross-examined PW1, he did not do that, my lord. Even in the absence of the husband, my lord.
The court can understand for everything there is a procedure. If he is not cooperating, there is a procedure for that. Procedure is not granting interim maintenance without an application.
125 itself suggests, my lord, that for interim maintenance, there is no specific provision at all, my lord, to file an application.
Then how the court will understand that what is the amount?
But it has gone through the entire, my lord, the status and
Then
all these
finally,
things.
then it means interim maintenance, finally court has to pass an order under 125.
But there was opportunity to lead evidence for the respondent.
Please come.
That procedure was, my lord,
I
followed.
believe with orders passed on interim maintenance dated 7/2/2024. The husband is before this court. The wife has filed the criminal miscellaneous 56 of 2023 seeking maintenance. Now it is a grievance of the husband that the wife had not sought for interim maintenance, and the court without any basis has granted interim maintenance of an amount of rupees 10,000, which is bad in law.
There is basis, but application is not there.
That is his argument. Without an application.
Application is there, not
Without
there
there
only
being an application and without any basis, the court has granted maintenance of an amount of rupees 10,000.
10,000 each petition.
10,000 to each petitioners, 10,000 to each, that is 20,000. And from the date of the petition, like counsel for the petitioner submits that, and the court has ordered maintenance, interim maintenance from the date of this petition, without there being a petition seeking interim maintenance, it is submitted that the court, without an application and without an opportunity to the respondents, cannot or not to have granted the maintenance. Next paragraph. When counsel appearing with the respondent submits that when the application and the criminal petition is filed in the year 2023, the husband is not cooperating and he has not appeared and he has not cross-examined, and the court, having no other go, had granted maintenance, he submits that there is no provision under 125 CRPC to file an application for interim maintenance. Court, having considered the plight of the wife, had granted the interim maintenance, and even till now, the husband has not paid any amount. It is submitted that the order passed by the court is a reasoned order and no interference is called for. Next one. Both the counsels have the learned counsel appearing for this, having heard the counsel on either side peruse the material on record. The learned counsel for the respondent has argued extensively, stating that the order is a reasoned order and no other application is required, and about the non-cooperation of the husband and how he is not appearing before the court, and which made the court to pass this order in spite of all the submissions that are made and the act of the husband. Still, a procedure is required to be followed by the court when the wife herself is not seeking any interim maintenance, and on that no objections are filed by the respondents, and just like that, on the ground that he is working and without even any discussion what is his income and other things, just like that, granting an amount of rupees 20,000 as maintenance is not appropriate.
No, he was a software engineer.
But where is the income? What is that is decided? I've seen that.
There is no denial of the occupation by the
In that view of the matter, this court deems it appropriate to set aside this order and remand the matter to the trial court. If the wife requires any interim maintenance, she should file an application, and within 15 days from the date of filing of the application, the husband shall file his objections, and from there on, within 2 months, the court shall pass appropriate orders accordingly disposed of.
order. The conditions those were prevailing for passing this order, they also have to be considered on granting arrears of maintenance.
She has not filed, that's the whole problem. Yes.
That's one submission. Pursuant to this order, the husband has paid maintenance to the wife.
That you can state before the court. Yes, next matter. 38. Yes.
It was in fact allowed on 6/11/24. Since my learned friend made a request, this honorable court was pleased to recall and post this matter. This is a case where, my lords, I am the owner of the premises who has executed a lease in favor of the respondent who is running a bar over there. Now, after completion of the lease period, I made a representation to the excise authorities saying that the building is in dilapidated condition.
Oh, yes, I remember that. Yeah.
Now,
yes.
he said that he has been paying me rent till June, my lords, which is totally far from the truth. What has happened is, subsequently, though he has sent various checks to my client, he has preserved those checks and he has not submitted them for encashment. Thereafter, once I made this representation in the 5th month, he makes a deposit in the 6 months and files that objections here. That is how even the client is present.
No, it's not the client. When his term is going to complete?
Please, not.
When
February 2024 itself it has completed.
No. Now the next renewal.
Next renewal comes to an end of February 2025.
30/6/25.
30?
Till 30/6/2025.
Till June.
Till June 2020.
Another 6 months.
And make arrangement for a different premise. My clients only say.
No, what we will do is, we'll ask them to file an undertaking that they will search for the premises, and by 30/6/2025, they will vacate the premises. And on such undertaking, we will let him continue. Because in the middle of now, he has that license period now.
Invested a huge amount, my lord, and even 4,50,000 is paid towards.
Now, he understands English. हिंदी हाँ हिंदी समझते हैं अभी क्या होगा उनका लाइसेंस जून तक है अभी कुछ ऑर्डर दिए फिर उसके ऊपर अपील करे पूरा इसमें आपका वो जून भी आ जाएगा अभी मैं क्या बोल रही हूँ उनको है ना वो एक अंडरटेकिंग फाइल करेंगे कोर्ट के सामने की बाई 36 वो लोग विकेट करेंगे प्रेमिसेस तो इसलिए जो हो गया वो 36 तक वो लोग वो खाली करेंगे वो अंडरटेकिंग कोर्ट के सामने देंगे अगर नहीं करेंगे तो वो कंटेम्प्ट हो जाता है आपको भी अच्छा है आप भी अपना अपना प्रेमिसेस जो भी कर सकते हैं आप कर सकते हो एंड तब तक तो रेंट भी पे करेंगे नो मिस्टर काउंसिल we'll ask them to pay the rent also till the 36.
Arrears of rent.
Arrears.
Not encash those checks.
Let him encash. Now that they're due or they're expired. When are the checks? Validity is there. Validity. Then to do one thing. We'll have this matter on Monday. Till June, from the time whatever are the arrears till June, that is 36/2025. Whatever are the arrears of rent and the future amounts, you give a check to him. And let him deposit on Monday. But you give a check, let him deposit on Monday, and this matter we will take it up on Thursday. And by that time, if that check is honored and he realizes the amount, and on that day you should also file on Monday. You should file an undertaking that by 36/2025 I will vacate the premises. Or else I have to allow this writ petition. Your client has no alternative. You have to because you can't compel the owner to give you on license forever.
The very contention submission of this response number 4 is the building is not at all in dilapidated condition.
Whatever it is, tell the court, can you compel a owner to give his premises for you for eternally? Under which law? You are not entitled to. First of all, if this court dismisses it, it has to be dismissed right now. Because without an lease deed, how can they grant you permission? It has to go because he is making a submission that he has already paid the amount. This is what he is considering. So we'll have this matter on Monday. By Monday, you have to give the entire check till from the arrears to 2025 June, and also an undertaking before the court that you will vacate the premises by 36/2025. And if you are not ready for that, we will dismiss the writ petition.
Instructions.
Tell your client, I'll pass orders on Monday. Yes, this is matter on Monday. Tuesday. Why auspicious day? Yes.
17.
This is matter on Tuesday. Yes, next. No pass out today.
We can give you adjust.
This is matter after vacation on 7th of January at the request of the council with petition. Interim order is there. If it is there, look at it. Yes, next.
Other than 7th is Monday. 7th is Monday. Other than Monday, any day.
No, Tuesday. January 7th is Tuesday. Yes. Is 43? No.
Connecting case.
That is also will.
Yes.
Yes.
Joint memo was to be filed by.
Not filed till now.
No. We have done the signature memo. But
Where is the council?
Not.
Not in your case. It's a different case.
Okay.
Yes.